Here at Scott Legal, we've processed hundreds of E-2 visa applications. While past results don't predict or guarantee future outcomes, we have a 98% E-2 visa approval rate. Some people ask about the 2% who are not approved, wondering, why do E-2 visas get denied? This video summarizes, in no particular order, the 6 most common reasons that E-2 visa applications are denied. In doing so, it also highlights ways that an applicant can make their E-2 application stronger. Reason 1, the investment amount is too low. To qualify for an E-2 visa, the applicant must invest a substantial amount of money in the U.S. business. The actual amount that must be invested depends on the type of business and certain other factors. In general, any investment amount under $100,000 will likely raise questions by the officer. However, even investment amounts over $100,000 could raise questions, depending on the type of business and which consulate is reviewing the application. For example, an E-2 business that manufactures cars would be expected to require a larger investment than a law firm would. And, a government official would likely expect to see far more than $100,000 invested in a car manufacturing business. Reason 2, the nature of the business is risky. Certain businesses are riskier simply because they involve more speculation. Among those E-2 businesses considered least risky are those involving the outright purchase of a business that already has profits and employees. This is not surprising. It is easy for the government to see how a business will be viable and employ U.S. employees if the business is already doing so. For this reason, franchises also often make strong E-2 visa cases. Even if an E-2 applicant is starting a new franchise location, the applicant can point to the franchise's track record of profits and employment to show that the E-2 business will be profitable and employ U.S. workers. While consulting and other service-oriented businesses are typically viable E-2 visa businesses, they tend to be riskier cases than those involving an outright purchase of a business that already has profits and employees. Among the riskiest businesses for an E-2 visa are investment businesses and real estate businesses. These are often subject to enhanced scrutiny by the government. One of the challenges they must overcome is that an E-2 visa cannot be used as a passive investment. The E-2 applicant must have an active role in managing the business and its employees and generating a revenue. However, even these relatively risky businesses may be approved if the application clearly shows that the business will support employees and will be an active, rather than a passive, investment. Reason 3, the filing location or venue is not amenable. Some consulates are simply more difficult than others. In some cases, the consulate may not be familiar with E-2 visas. In other cases, the consulate may be accustomed to seeing a certain type of cases, or a certain dollar amount for investment, and will more readily approve those cases. Officers are rotated every few years, so policies at a specific consulate can change. A good E-2 filing location today could become a difficult location overnight. In addition, individual consulates may focus on specific aspects of the E-2 application. And U.S. Citizenship and Immigration Services, or USCIS, which reviews E-2 change of status applications, may have different areas of focus from a consulate. For example, USCIS tends to closely scrutinize the source and trail of funds invested in the business. By knowing your application's strengths and weaknesses, and having an understanding of what the different filing locations look for, you can think strategically about which application location gives you the best chance of success. Reason 4, the adjudicating officer you get, or luck of the draw. Reason 4 is related to reason 3. Visas are issued at the government officer's discretion. When you apply at a consulate, which is where most E-2 visas are adjudicated, you are not afforded any due process. As such, you cannot appeal a denial, and the decision of the officer is final. An officer could simply be having a bad day. One little thing the applicant says could be the difference between an application that is approved, or one that is denied. Reason 5, the adjudicator does not think the E-2 business will generate jobs for U.S. workers. This is a very difficult denial reason to overcome. The main reason the E-2 visa exists is to create jobs in the U.S. As a result, the adjudicator will look at the viability of the business, and the ability for the business to hire U.S. workers. When the initial application is made, the applicant should have a solid business plan, as well as other documents to show that the business will be viable and hire U.S. workers. Applicants who want to start the same business that they have in their home country will face challenges if the existing business is not profitable, or if it does not have employees. Reason 6, the applicant does not meet the requirements for an E-2 visa. We have had clients who came to us after they applied for an E-2 visa without a lawyer and were denied. In some of these cases, the applicant was clearly not eligible based on their submission. For example, in one case, The applicant did not spend anything on the business. Instead, they simply transferred money into a business bank account. The application was denied, since it clearly did not satisfy the government's requirements. It is important to make sure to satisfy each of the government's requirements for an E-2 visa. A qualified immigration lawyer can help ensure that you do so. If you are considering an E-2 visa, or have questions about how to strengthen your E-2 visa application, Scott Legal is here to help. You can contact us by calling 212-223-2964, or by sending us an email. We look forward to hearing from you. You can also schedule your consultation by clicking on the link below, where you can choose a day and time that is most convenient for you.